Welcome to my channel. Please like, comment, and subscribe. In this video, we are going to talk about what is negligence under maritime law. For maritime workers in Louisiana or any location across the Gulf Coast, your physical ability is critical to your livelihood. It is equally critical to make sure you are compensated for your injuries if you have been seriously hurt while working. Your health, future, and your family need to be protected. Call the maritime injury lawyers at Domingos, Wright, Roy, and Edwards to discuss your rights to compensation if you have been injured while working in the maritime industry, and they will protect your rights. Land-based workers who are injured on the job are generally covered by workers' compensation under federal and Louisiana state law. However, if you're injured while assigned to work on employer vessels, you might qualify as a Jones Act seaman and be entitled to recovery under the Jones Act. The Jones Act was enacted in 1920 by the United States Congress to grant seamen foreign and domestic a cause of action against employers for negligence. The Jones Act gives a seaman who suffered a personal injury during employment the right to seek damages in jury trial. Under the Jones Act, the employer has a duty to provide a seaman with a reasonably safe place to work. This duty is absolute. If the negligence of an employer played any part in the injury to the seaman, no matter how much or how small, even if the Negligence Act are in combination with other acts or in combination with some other cause, the employer is entirely liable. Injuries on ships can often be caused by the negligence of a fellow crewman, but the employer is still responsible. Seamen who has pre-existing injuries are also not barred from claiming damages under the Jones Act. The employer and/or vessel owner are liable for an aggravation or increase of an injury due to negligence or unseaworthiness. Under the Jones Act, there is no assumption of the risk defense for an employer or vessel owners. A seaman does not assume the risk of the Jones Act negligence of his employer. Under the Jones Act, a seaman damages may only be reduced by his comparative fault, if any. Our skilled maritime injury lawyers represent injured or disabled workers. We don't get paid unless you win. We're very confident in our ability to get you the benefits you deserve. And now, who is covered by the Jones Act? The Jones Act covers employees who work as a seaman. Under the law, the term seaman has been defined as a person who performs a significant amount of the jobs on the vessel. It is not always simple to determine that qualifies as a seaman for the Jones Act. There are often disputes over this issue, but many types of workers qualify as a seaman. Do not assume that you do not qualify for protection. If you are injured while working on a boat or ship, speak to an experienced attorney about your case. Generally, a seaman is a person from crew member to captain who performs a significant amount of his or her work on a vessel, any types of a ship or boats. Part-time seamen must spend at least 30% of the time working on a vessel to qualify under the Jones Act. And then what does the Jones Act do? For maritime workers, the most important thing to understand about the Jones Act maritime law is that it provides a method for a seaman to file a lawsuit against negligence employer. Under Louisiana laws and throughout the United States, most injured workers are prevented from filing personal injury lawsuits against their employer. Instead, they are required to pursue financial support through a workers' compensation claim. However, the Jones Act gives injured maritime workers the right to hold negligence employer liable and the right to a jury trial. What is negligence under the Jones Act? Negligence is the failure to take due care or adequate safety precautions. The Jones Act requires all covered employers to ensure that maritime workers provide reasonably safe condition on the job and their vessel are maintained and keep in reasonably safe condition. If an employer fails to take proper safety measures and work suffers an injury, the employer can be held legally liable through a Jones Act injury claim. These cases are fact-specific. If you or your loved one suffer an injury while working on a boat or a ship, speak to Louisiana Jones Act attorney immediately. Call Jones Act attorney to discuss your right to compensation. If you are injured while working on your employed barge, commercial fishing boat, tugboat, or ship, you may have rights that are different and more valuable than the rights of an injured land-based worker. Those injured while assigned to work or on any vessels in navigable waters may qualify as a Jones Act seaman and may be entitled to recovery under the Marine Act, also known as the Jones Act, or General Maritime Law for unseaworthiness. The definition of a vessel under the Jones Act is very broad. Vessels that are docked and anchored are still vessels under the Jones Act unless they are permanently taken out of service and not capable of navigation. These federal laws allow you to recover compensation for loss of income, disability, inconvenience, pain and suffering, lost wages, loss of earning capacity in the future, retraining. You may qualify for a significant award under these laws. Also, claims for maintenance and cure allow injured workers to recover out-of-pocket losses for medical expenses and living expenses until you reach the point of maximum medical improvement. The Jones Act and maritime law can help workers injured aboard construction barge, tugboats, marine cranes, tankers, jack-up boats, dredge, drill ship, towboats, pile drivers, and other vessels involved in the maritime industry. Determining your legal rights and maximizing your recovery after an injury can be complicated. Your employer and the insurance company may try to reach a rapid settlement. Although their offer may sound good at the time, it is important that you do not settle. They encourage you not to sign anything or share details about your injury after speaking with an experienced Jones Act attorney. The statute of limitation for filing claim under the Jones Act is 3 years from the date of the accident. The Jones Act and Admiralty lawyers of DeMongo, Wright, Roy, and Edwards will work on your behalf to make sure every negligence party compensates for your injuries. And then the lawyers are highly experienced in offshore injuries, commercial diving injuries, and helping oil and gas industry working in Louisiana as well as across the globe. I think that's all, guys, the information that I can say to you. Thank you so much for watching. And if you need information about maritime law or maritime topics, you are in the right channel, because in this channel we talk about it a lot. And if you want us to discuss about maritime law, you can drop your comment below, and later when we have chance we will talk about it. And don't forget to share this information to your friends too. Maybe your friends need it. I think that's all the information that I can share to you guys. Don't forget to give like, comment, and subscribe. Bye bye. See you in another video.